Weeks from sentencing, Derek Chauvin's case takes yet another turn. This evening, the defense team filed a 4-page motion requesting a new trial and detailed a number of errors they believe were made during the trial, which violated Chauvin's constitutional rights to a fair trial. Requesting a new trial isn't uncommon, but one of the grounds listed is getting a lot of attention, and we're talking about juror misconduct. Juror number 52, Brandon Mitchell, is responding to questions about his motives, his juror questionnaire, and the March on Washington he attended last summer in D.C. We have a lot to get to with my next guest, or my first guest of the night, that is, who's had his fair share of high-profile cases. Joining me from Miami, prominent criminal defense attorney Mark O'Mara. Thank you so much for joining me, Mark.
Great to be here.
All right. So prospective jurors were given a questionnaire to fill out during the start of jury selection in this case, and there were 2 questions that could be at issue. From a jury questionnaire during jury selection, the first question read, did you or someone close to you participate in any of the demonstrations or marches against police brutality that took place in Minneapolis after George Floyd's death? There was a box for yes, me, a box for yes, someone close to me, and a no box. Now, the event Mitchell attended was the March on Washington, so technically he answered no truthfully. Second question, Mark, was, other than what you have already described above, have you or anyone close to you participated in protests about police use of force or police brutality? Yes or no, to which Mitchell also answered no. We now know that Chauvin's defense team plans to appeal his conviction, obviously on various grounds. It's par for the course, right? And you and I know that this revelation alone, that this juror attended the March on Washington, wouldn't be enough to overturn that conviction. But this, combined with all those other grounds, for example, the judge's refusal to move the trial, the announcement of that massive civil settlement, could that give the defense a real shot on appeal to get Chauvin's conviction tossed?
Well, I think the judge has to give the motion due consideration, has to consider every paragraph. Of course, right now we just have the bald allegations from the defense team. They will now brief it. We'll have the case law that supports or doesn't support their position. And through their arguments and exhibits that they may bring forward, there'll be a lot more information. So we have to look at them individually. For example, that you should have moved it to another place in Minnesota. I think that's not going to get very much yardage with the judge because, first of all, this case was known internationally. So no matter where you try in Minnesota, that's not the point. The point is getting a jury who can be fair and impartial. Same thing with sequestering the jury. I don't think a judge is going to say, no, you're right, I should have sequestered it, because there are a couple of little things that may have gotten to them. Again, something to consider, but I don't think they're going to get very much yardage out of it. Now, talking about the juror, the first question, let's just say there was only the first question. Did you attend a rally or protest in Minneapolis? No. Perfect answer. Stupid question, quite honestly. Way too limited. But then they did have that follow-up question where they do suggest that, okay, anywhere else. Now, one, maybe he should have answered that question and said yes. But then the question also becomes, this is not the only way. I don't like questionnaires because you get sloppy with them. I think you go in there and say to every juror, and quite honestly, including those jurors or potential jurors of color, and ask them more questions about that. You know, people in your family, you know, what do you feel about the situation that we're dealing with in America today? If that wasn't properly looked into, then that is squarely on the defense attorney's shoulders, because that defense attorney is primarily responsible, if you think about it, along with the judge, of getting a fair and impartial juror. So I think this is going to be listened to by the judge, but I do not see a new trial on the grounds presented so far.
Well, to your point, the defense actually questioned this juror about his responses as it relates to the Black Lives Matter movement, and this is what happened in that exchange.
You were asked a couple of questions about both the Black Lives Matter movement and the Blue Lives Matter movement. You indicated that you have a very favorable impression of the Black Lives Matter movement, and you wrote, Black lives just want to be treated as equals and not killed or treated in an aggressive manner simply because they're black. Can you just explain that a little bit more?
All right, so Mark, we didn't have the actual response from the juror, but to your point, the defense attorney asked him about his responses, and he was the 6th juror that was selected.
So, you know, if we can just get just be real straight up, Is there any person of color in America who isn't aware of the biases that exist in the criminal justice system and that Black Lives Matter was created in response to that? So the idea that any criminal defense attorney on behalf of a white defendant with a black victim isn't going to take on the responsibility, or doesn't take on the responsibility of vetting those potential jurors of color and look into this, then it's almost malpractice. I mean, again, I think Nelson did a great job trying, but look, it is on his shoulders to try and do that. He did it. He gave the opportunity to the juror. I did hear what the juror said, not tonight, but other times, and it was a good, straightforward answer. And quite honestly, it makes sense that they're going to look into it. But to now go back and say, wait a minute, he didn't tell me that he went to a program out in DC months before, and he was wearing a T-shirt that evidenced his concern about Black Lives Matters and those movements, and even what Chauvin did. But that's up to them. And here's another thing. We talk about this, and I actually train lawyers on social media investigation when you're looking at jurors. And I call it malpractice if you don't do it. But let me tell you something. If you are not doing intense social media investigation of your potential jurors, then that's on your shoulders again, because that's the way you're going to get this information out. So again, I don't think that the juror did anything wrong from what we have to date. And Chauvin's attorney and the defense team behind him really has the responsibility to vet these issues out. It's not up to the prosecutor and not even up to the judge.
Well, the motion for new trial that was filed by the defense today included allegations of errors made on the part of the judge. It read in part, the publicity here was so pervasive and so prejudicial before and during this trial that it amounted to a structural defect in the proceedings. The court also abused its discretion in not granting a change of venue or sequestering the jury. Did the judge make the mistake of not sequestering this jury or moving the trial?
I said, and Yodit, you and I talked about this, I think, we may live in a society now with the enormous focus on criminal trials, particularly those that involve issues of race, that we may have to tell our juries, you know what, you're going to be with us for a month and you're going to be in a hotel room. Because we're now getting to the point where there is this potential of infection, where there is so much focus on a case like Chauvin that people may try to impact or infect the jury. So we may have to tell those in the future. But the law of the land today is that the judge has a lot of discretion as to how to handle his jury. And what he did was he was very careful, in my opinion, of keeping them free from the infection, of telling them what to do and not to do, about don't listen to this, don't look at that, stay away from this, don't let your family talk to you about that. He did a good job. And I think with the minimal amount of infection that we have seen happen to date, the Congresswoman is one, for example, unfortunate as that was, because I don't like when people, when Congress people or anyone talk about a trial when it's ongoing. But nonetheless, the judge did what he needed to do. And these people, 12 people, had common sense. They live in this world with us. They know this stuff. And I think they did a good job of doing exactly what the judge told them, which was follow the law and apply the facts.
I've said this before, but this was one of the most consequential trials we've seen since OJ, and that jury was sequestered, and I believe they should have been in this case, but sequestering this particular juror wouldn't have changed the fact that he attended a march last summer. Now, you mentioned these 12 jurors in total. People are forgetting that there were 11 others on this jury and that this verdict had to be unanimous. What about that aspect? Why are people putting so much focus on just this one juror?
Well, the defense team, that is what they're supposed to do. And I do it myself. If I can find a problem there, I'm going to bring it to the judge's attention in a new trial motion. We do them all the time. You almost have to do them. But yeah, that's part of it. Now, let me give you an example of what might have been really significant. Let's just say that this juror was the sole juror seeking conviction, and 11 people wanted an acquittal. And that now came out. Now you may have a question. Now you may say, okay, that is problematic. But again, in that case, all you do is you have a new trial anyway because you have a hung jury. But if there was something like that came out, I would give it more credence. But you're right. He was one of 12, every one of which came out and said a guilty verdict. And don't forget, we found out since then from another juror who spoke that they were pretty certain after the first 45 minutes to an hour of conviction of all, but there was one juror who they had to sort of talk into for several hours. So again, there didn't seem to be a lot. There was overwhelming evidence. And that also leads, don't forget, to the standard that we have in looking at these type motions and appeals, which is that harmless error standard. There was certainly enough there that even if there was some error, it was harmless because of the overwhelming evidence of guilt. And that, I think, is going to be the filter that both this judge and the appellate courts look at with this trial.
All right, defense attorney Mark O'Meara, thank you so very much.